Welcome, everyone. Thank you for joining us today. We're going to be talking about immigration options for survivors of domestic violence, sexual assault, human trafficking, child abuse, and child neglect, and the court's role. And before we start, I wanted to let you know that we are all members of the National Judicial Network, which NewApp staffs, and our partner in that is the National Council of Juvenile and Family Court Judges. If you are a judge or you work with judges who you think would be interested in joining the network, if you could show the next slide, please. We currently have 131 members from across the country, and we're looking for more judges to join us. After the webinar, we'll send you a link to materials, and it will have a link with the advertisement to join the network, and I hope you will decide to do so. Next slide, please. The network has peer-to-peer sessions for judges that are judges only to talk about emerging issues. The next peer-to-peer session is on human trafficking screening tools for courts. It's going to be presented by staff from DC Superior Court. And then we have sessions planned through 2022. They happen approximately once a month. We do take off the summer. And then the next national webinar that we're going to be offering is going to be regarding adult victims of human trafficking, the judicial role, and it's facilitated by Judge Toko Sarita from New York. Next slide. And so the following slides, you should know, are intended to be a guide for today's presentation on this topic and but also provide you substantive material for the future. So there are more slides than we're going to be covering in detail today, but we have them for you as a reference. You're encouraged to type questions in the chat throughout the presentation, and we will address them during the webinar. And if there are responses that go on, there are more questions than we can answer during the webinar, we will answer them and follow up to all of the participants. Next slide, please. And then at the end of this session, please don't forget to do the session evaluation. And I want to also let you know this session is sponsored by the State Justice Institute and the U.S. Department of Justice. And the views that you will hear today are mine and my fellow judicial presenters, and they're not the views of the State Justice Institute or the Department of Justice. Next slide, please. So I'll start with myself. I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University, Washington College of Law, and NewApp provides training and technical assistance nationally on issues related to immigrant survivors. And we're happy to have you join me today. And I'm very proud to be presenting with Judge Briel and Judge Breslow. I think I will turn this over to Judge Breslow first.
Hi, everybody. I'm Judge Breslow, Julie Breslow, and I've been a magistrate judge in DC Superior Court since 2002. For that entire time, I've covered a child abuse and neglect docket. But in the last 3 years, I started doing custody cases where special immigrant juvenile status is being sought. And I also cover some divorces and occasionally some domestic violence cases, occasionally delinquency cases. And I'm excited to be here today.
Good afternoon, everyone. My name is Susan Briel. I'm a judge in the San Francisco Superior Court, and I've been a judge for 20 years. I currently have a juvenile dependency court assignment. Before that, I handled juvenile delinquency cases for 4 years, and I've handled a lot of other assignments, including felony, serious jury trials for over 10 years. And I also handle all U visa certification requests for the civil division of our courthouse. And I'm really so honored to be here because, among other things, I think understanding immigration options is so incredibly important for us judges because these options help families who come before us access services and benefits and allows them to become independent from their abusers. It also creates stability for the families who come before us in our courtrooms, and it helps ensure that all parties, both immigrant, both citizen and non-citizen alike, have equal access to justice in our courtrooms. So let's take a look at our learning objectives for today. Next slide. There we go. At the end of this webinar, you will better be able to identify potential relief for parents and children and understand your role in assisting the parties in accessing immigration relief. You will be better able to know how to sign U and T visa certification requests, issue special immigrant juvenile status findings, and know how to access legally correct information about immigration law. So going to the next slide, Congress actually created immigration relief in order to protect crime victims. And Congress also recognized that us judges are in a very unique position to make certain predicate findings to assist victims in accessing immigration relief, because we often make these findings on a daily basis for non-citizens and citizens alike in our courtrooms. Professor Orloff, take it away.
Yes, and so the place I like to start is to help people understand that when you're a judge and you're working on a case and it identifies somebody, either through testimony or evidence or however else, you detect or you believe that a person has suffered domestic violence or child abuse or sexual assault or any of these criminal activities that and forms of abuse that are listed on this slide, you are looking at someone who, if they are a non-citizen, will be eligible for one of the various forms of immigration relief that Congress created to help crime victims. And so you can play a really important role in helping identify people who qualify. And just so for those of you, the dark colored ones, the ones in bold, are child abuse, abandonment, and neglect that qualify for special immigrant juvenile status, and all the other criminal activities, which often, as we'll see when we talk about our hypo today, go together with child abuse and neglect and other forms of abuse, are covered by the U visa or the T visas, and we'll be talking about those today. Next slide, please. So this is a tool that the Department of Homeland Security created and published in 2017. And it's it will be in the materials. We're going to give you a link to materials website today that we've created for you. And perhaps Daniela, while I'm presenting, you can put that link in the chat to the web materials. But it's a document that when you have the electronic version, you click on the word U visa and it takes you to the Department of Homeland Security website on the U visas. You click on the little black boxes and it takes you to the place where you can download the most current forms. But I'm basically talking about it today to give you an idea of how simple it is to tell whether you're working or you're with a crime victim, or in your court, there's a crime victim who may qualify for one of these forms of relief. And the simplest way to talk about it is a VAWA self-petition, and we'll go into much more detail as this progresses today. A VAWA self-petition is available when the abuser is either the US citizen, spouse, child, or over 21-year-old parent of the family, the victim, the family member who's been battered or subject to extreme cruelty. They're eligible for VAWA self-petitioning if a lawful permanent resident is abused by their spouse or parent. And interestingly, under immigration law, the definition of child always includes stepchild. So stepchildren have the same legal rights as naturally born children or adopted children under immigration law and are covered by these laws. The U visa, so that covers a certain slice of the domestic violence and child abuse population, but not all of them. The U visa, or let me go to the next one, special immigrant juvenile status. Oh, not the next slide, please. Can you go back? Special immigrant juvenile status is the way to think about this one is anytime a parent or step-parent has abused, or an adoptive parent has abused a child anywhere in the world, abused, abandoned, or neglected, the child who's in the United States can qualify for special immigrant juvenile status. Abuse could have happened here, could have happened abroad, and we'll be talking about that in detail. For victims of human trafficking, there's a special visa called the T visa and something called continuous presence. Those two forms of relief help trafficking victims who've been victims of sex or labor trafficking, and we'll go into the details of what that means, but it's either sex trafficking or labor trafficking, somebody who's been subject to force, fraud, or coercion generally. There's some exceptions to that. And we'll talk about that. And then finally, the U visa is kind of the catch-all. So we've talked about these very different kinds of coverage for child abuse and domestic violence and for trafficking victims, but the U visa has that broader list of crimes. If you could go back just a second, one slide, Daniela. It's this list of crimes that you'll have as your resource, that any of these criminal activities can qualify somebody for a U visa if they've been helpful in coming forward to a court, to a police officer, to a prosecutor, to the EEOC, and revealing facts about the abuse, the crime victimization that they've suffered. 2 slides forward, please.
So you may be wondering, what are the benefits to survivors that would be offered by these different forms of immigration relief? I mean, the most obvious one is protection from deportation, but also giving victims some sort of a path to a legal immigration status is important. Particularly in cases that we see before us in the domestic violence court and also elsewhere in family court, you want to think about financial independence for a victim from the perpetrator. And then there's also the issue of Vowel confidentiality that allows groups that receive money under the Congressional Violence Against Women's Act to get some protection, the ability to protect the confidentiality of victims. And that's something that Professor Orloff may be able to shed a little bit more light on. But these are the basic benefits that we'll be thinking about today when we talk about victims.
And Professor Orloff published recently a really important and relevant study about how pursuing these immigration options can help families in our courts stay stable and
next slide, please.
And can help our families with becoming independent from perpetrators. So hopefully you can talk about that, Professor Orloff.
Absolutely. First, let me say that the Violence Against Women Act confidentiality, in addition to what Judge Bressel was talking about, has some special protections for immigrant survivors. You can go to the next slide, please. And that it basically is the first form of protection from deportation that immigrant survivors receive when they file one of these immigration cases. And what we see is a dramatic change in once victims file an immigration case, they get some initial protection from Vowel confidentiality. But when their case is actually reviewed and they get work authorization and something called deferred action, which is formal protection from deportation, it means DHS has decided not to remove them. You see dramatic changes in their lives. And dramatic changes in their involvement with the justice system. There's a 114% increase in willingness to trust the police. More people are willing to report future crimes. Judges report and family lawyers report a decline in immigration-related abuse issues coming up and in the courtroom. There's also declines in child snatching and use and immigration-related abuse altogether. Next slide, please. But we also see, importantly, increases in participation in the justice system. I mean, significant immigration. Once victims file their immigration case, they're much more likely to seek protection orders, custody, and participate in the criminal justice system. Next slide, please. And importantly, it's not only about the adults or the primary applicant, but victims' children also are included in their application, or they may have citizen children. And what we see is for immigrant victim parents, a six-fold increase in their involvement in their children's school, and their children become more socially active and involved in, healthier behaviors for themselves as well and pursuing their own interests. Next slide, please. And that we also see significant mental health benefits for the immigrant parents, and not only parents, but crime victims who file for, once they receive work authorization protection from deportation, they become much more able to function and benefit. There are really benefits to all of this in terms of mental health as well. And then there's economic improvements, and this is quite dramatic. You see like a 300% increase in their ability to get a job that earns a minimum wage. You see them paying more taxes, having better job security, getting benefits, all of these kinds of things. Next slide, please. And you see them essentially learning English at much higher rates, affirmatively taking steps to learn English and to be able to function more in our society. And also significant numbers of them pursue GEDs, bachelor's degrees, associate's degrees, and all kinds of education. Next slide, please. And so these for your reference for later, we have information. And I guess I'll just say that these improvements continue through the process of when victims gain lawful permanent residency, and they get better and better over time. So as we're going to be talking about today, the first step for victims to be able to get these forms of relief are the types of immigration cases that judges can get involved in playing a role in. Next slide, please. Next one. Keep going. Here we go.
So, Professor Orloff, is there a way if participants want to get your actual study, they can do that?
Yes, we will include it on, Danielle, if you can make a note, please, we will add it to the webpage that we distribute today. We'll give you a link to the full report. We have an executive summary, and then we have a 20-page version that has like the conclusions and recommendations, etc. But yes,
Great.
we will make it available to you.
So we're going to refer to this hypothetical that you see on the slide throughout the rest of our webinar. And this is a hypo involving Clara. Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 12-year-old daughter, Juanita. Juanita's father abandoned her when she was an infant. After becoming pregnant, Clara gave birth to a baby girl, Lupe. Eduardo decided to bring Clara, Juanita, and Lupe to the U.S. to live with him. When they arrived in the U.S., Eduardo took Clara, Juanita, and Lupe's El Salvadorian passports and became physically and sexually abusive to Clara. Within a year following their arrival in the U.S., Eduardo forced both Clara and Juanita to work for his family's business and never paid them for their labor. One night, when Juanita was 14 and Lupe was 2, Eduardo flew into a rage and beat Juanita and Lupe severely with a belt. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors called the police for help, and Clara talked to police when they arrived. The police arrested Eduardo for attempted murder and sexual assault of Clara and child abuse, as well as aggravated assault for both children. The police took Clara to the hospital and the children were placed in foster care.
So Eduardo was convicted of sexual assault and attempted murder of Clara and child abuse or aggravated assault of both kids, and he was sentenced to a long prison term. Lupe's and Juanita's neglect cases were assigned to me, Judge Breslow, and both children were adjudicated neglected children. And I granted ultimately Clara's request for sole legal and physical custody of both children, and I continued the case for monitoring. Unfortunately, Juanita then ran away from home and was taken in by friends who trafficked her, forcing her to engage in sex with men in exchange for money. And after being in runaway status for a year, Juanita did return to her mother. So the question for all of you is, what form of immigration relief would Clara, Juanita, and Lupe qualify for? So are participants able to?
Daniela, do we have the thing where they can check the boxes?
No, we do not have that.
Great.
Okay.
So what we can do is in the chat, why don't you guys put the numbers of the answers to the questions? Sorry about that, guys. Of what you think you're seeing. I see one person has said C. You guys see the chat
Anybody
button?
else?
Can see an
Got an
A.
A.
Let you process it.
Someone
All
said
right.
B.
Responses are coming in.
We got some A's and some C's and some all of the above. Alrighty, so I believe the answer is A and C. The U visa, let's see, Clara qualifies for the U visa, right? Because she's a victim of a crime and she cooperates with the police by reporting this crime and presumably with the prosecution. The T visa, and I hope I get this right, she's also eligible for the T visa, Clara, the mother, because of Juanita. I believe that's
Actually,
the
it's
answer.
because she was forced to work without
She was
pay.
forced to work.
So
Labor
she's a
trafficking,
victim
which
of
is
labor trafficking.
right. I always forget about the labor trafficking, but they don't qualify. The answer is not B, all of the above, because Clara does not qualify for VAWA self-petition. I believe that's correct. Is that right?
That's right. And it's
She
because
wasn't
she's
married.
not, because she's not married to Eduardo. And if
Right.
there was a marriage, it would be all of the above. And that's kind of, but how it works and how you can see that victims have various options.
That was
Back to you.
tricky.
Next slide, please. And that you can see here the U visa requirements, which we're going to be talking about in more detail. But basically, it's a victim of qualifying criminal activity who's been helpful or is being helpful or is likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of a crime, of a criminal case or criminal activity. And judges certify based on detection, conviction, and sentencing because you guys don't investigate or prosecute. And victims can be helpful to the courts or to prosecutors or to law enforcement or a number of other government agencies. Next slide, please.
So now think for a moment about Juanita, the teenager. What form of immigration relief do you think Juanita would qualify for? So type your answers into the chat.
You.
I'm seeing
And
lots
you
of
can
C's
check
and
all that
D's.
applies. So you can list more than one. See a lot of C's and D's. Okay. Judge Breslow, what do you think?
So, well,
go ahead.
I think Juanita is not eligible for VAWA self-petition, as far as I can tell, because the mother wasn't married to Juanita's father.
Right.
But Juanita is definitely eligible for the U visa. She is also the victim of a crime. She's definitely eligible for special immigrant juvenile status because she was abandoned by her father. We don't think about Eduardo when we think about Juanita's special immigrant juvenile status. We think about her biological dad who abandoned her. And then she's also going to be eligible for that T visa. She's a victim of both sex and labor trafficking.
Next slide, please.
So just to recap a little bit on the special immigrant juvenile status, and we're gonna talk about this again down the road in this presentation, is your special immigrant juvenile status is an immigration form, a form of relief for unmarried children who have to be under the age of majority under state law. And one of the weird things about special immigrant juvenile status cases in general is that even though some of the behavior you're going to talk about in these cases may have occurred outside of your jurisdiction as a judge or as a lawyer, it may have occurred in another country, you're still going to be looking to your own local state law. So for me, I'm going to be looking to the laws of the District of Columbia for the definition of a child, the definition of child abuse, neglect, abandonment, or dependency. And the other thing that I always like to remind people about with special immigrant juvenile status is that the conduct only has to have happened by one parent. It does not need to be both parents. So thinking about Juanita, we're going to focus on that biological father who abandoned her. We're not going to focus on Clara, who's actually taking care of her. And the role for the judge in the special immigrant juvenile status cases is going to be really to listen to the witness who is seeking the special immigrant juvenile status, listen to the child when he or she testifies, and figure out, can you meet the elements of the SIJS statute based on this evidence so that you can certify in an order that the elements are met. You're not granting any kind of immigration relief. That's for USCIS to do. All you're doing is making findings. Do the facts that I just heard fit into my local definition of child abuse, neglect, or abandonment, and have the elements been met?
And we'll talk about all of this again in more detail. Next slide, please. So for trafficking victims, and for both the T visa and the U visa, so as Judge Breslow just said, in special immigrant juvenile status cases, judges will be asked to make findings that are prerequisite to filing the immigration case. In T visa cases and U visa cases, they'll be asked to make certifications or sign a certification form. And that certification form is mandatory prerequisite for U visas and is very helpful evidence in the T visa case. And so so basically T visas are for victims of severe forms of trafficking, sex or labor trafficking, involving a victim under the age of 18 or an adult where there's force, fraud, or coercion. The victim has to be physically present in the United States, and then they have to comply with reasonable requests for helpfulness when investigating or prosecuting the trafficking case. But that helpfulness, again, if they come to court and participate in proceedings before you and are ordered to come back and they show up, those kinds of things can be helpfulness for trafficking victims and can qualify for the T visa, and judges' role is certification. Next slide, please.
Okay, so Lupe, the toddler, what form of immigration reliefs would Lupe not qualify for? Let's see your answers in the chat.
This time it's 1. We've got somebody's put in A. Any other? Which one does she not qualify for? Other people want to jump in and guess? It's okay to guess.
All right, I'm going to jump in. So take a look at that T visa. Lupe was not trafficked. She was not a victim of sex trafficking. She was not forced to work. She's just a little toddler. So she is not going to be eligible for a T visa. She's definitely eligible for the special immigrant juvenile status. She was abused by her father. Remember, he was convicted of abusing her. Conviction isn't necessary, but we have it in this case. And she is also the victim of crime. So she's eligible for the U visa. And then the VAWA self-petition.
She's eligible for?
Because the parents are married.
Yeah. Exactly. Well, no, she's actually eligible independent because she is the daughter of a U.S. citizen. And,
right.
No, a lawful permanent resident. Eduardo is a lawful permanent resident. And if he's a resident or a citizen and he's her father and he abuses her, it doesn't matter whether there's a marriage between the mother and the father, the child is always eligible. And the child, by the way, if Lupe filed a VAWA self-petition, she could include Clara, her mother, in the application, but not Juanita, her sister. So that's one of these really why there's so many different forms of immigration relief, and you may have different people in the family applying for different things.
So
Next slide,
Professor Orloff, it's good to pursue all these avenues of relief, correct?
That is correct. Immigration laws encourage or require people to file for everything they're eligible for, because if you don't, you kind of forfeit those other forms of, the way to apply. You're encouraged to apply for all of them. And then you get the one that you get first, meaning that you become, if your T visa is processed first, you'll get T visa status and you won't need the VAWA self-petition or the U visa, and they'll just be administratively closed. So they're encouraged to, and then different forms of relief come with different benefits. So trafficking, one of the reasons you always want to look and try to identify trafficking, we're going to have more webinars on trafficking as well and have things available for you online, is that T visa applicants and recipients get more access to federal and state funded public benefits, things like healthcare and housing and post-secondary educational grants and loans and things like that, than do VAWA self-petitioners. So trafficking victims get the most, VAWA self-petitioners and SIJS are kind of in the middle, and U visa victims get the least unless you're in California or Illinois or New York. But that's kind of how it works. So there are public benefits implications to which you apply for, but you always want to identify everything that somebody applies for and then have them work with their advocate or the lawyer to decide which paths to follow. Long answer to a short question, sorry. Next slide, please. So just so you know a little bit more quickly about self-petitioning, a VAWA self-petition is for somebody who's subjected to battery or extreme cruelty. That basically is a definition of domestic violence that is broader than virtually every state protection order statute. It includes everything your protection order statutes, plus it includes forms of coercive control that may not be sufficient for your protection order statute. And it also includes forms of abuse, like those of you that might be around long enough, like I am, old for-cause divorce law. Some of the things that you could get a divorce for when you had to have cause would be sufficient for extreme cruelty. It was actually based on old for-cause divorce law. And there needs to be, so the judge's role here is very interesting, making findings that you might not think to make in a protection order proceeding about the fact that they're married, making findings about the existence of a parent-child relationship in a protection order proceeding or in a family court useful, findings about the abuse, findings about, did they live together? So in the immigration case, they have to prove that they lived together for some period of time. So if they only lived together for a month and then they separated, but you put that in your order, that could help in the VAWA self-petitioning cases. So detailed court orders can be very, very helpful, particularly findings of abuse, findings about the relationship, and findings about, residence together are the three big ones. Next slide, please.
So, Battered spouse waiver is something that has often confused me and many of my colleagues. And I'm hopeful you can explain not only what it is, but also a judge's role with regard to battered spouse waiver and why we don't see it.
Well, actually, I think you probably see these more than you think, or at least family court judges for sure do. So the battered spouse waiver is very much like the VAWA self-petition. The major difference, it helps spouses and children of U.S. citizens and lawful permanent residents. And the difference is that under U.S. immigration law, as soon as there's a marriage, a spouse can file for the U.S. citizen or lawful permanent resident spouse can file for their spouse, stepchildren, and naturally born children. You don't even need a marriage, but the abuser can file, or the spouse can file. And what happens is sometimes an abusive spouse files immigration papers for his child or wife or husband, his or her husband. And so the battered spouse waiver is identical to the VAWA self-petition, but it has less proof elements because the abuser has already submitted proof to DHS about the validity of the marriage. So this is somebody who got a green card based on the marriage, but it's a conditional 2-year green card, not the normal 10-year, because DHS assumes that all marriages are fraudulent and expects the parties to come back in 2 years together and prove, see, we're still married, it was valid. And for victims, so this allows the victim to get full lawful permanent residency without her abuser's knowledge, without waiting 2 years, and without having to stay in that relationship during that 2 year period. So it's very similar to self-petition. The main difference is in the battered spouse waiver, the abuser filed an immigration case for the victim. In the self-petition, as its title says, the victim self-petitioned for the remedy. That's the main difference. And battered spouse waiver is easier to get. And so you'll see it in divorce cases where somebody comes in and says, I can't get a divorce, or protection order cases or abuse case. In a child abuse case, for example, you want to encourage the mother maybe to leave, reunite if she separates from the abuser. And she may not want to leave because she believes she has to stay with him for 2 years. That could be how it comes up to a family court judge.
So a judge's role, similarly to the Vowel self-petition, would be to make findings of battery or extreme cruelty or threats and emotional abuse.
Exactly. Next slide.
Okay, so now we're going to do a little bit of a deeper dive into each of the forms of immigration relief that we've kind of given you an overview of. And we're going to start with special immigrant juvenile status. And the first thing I want to stress, I mentioned it slightly before, is just that I know that some judges, and I've talked to judges in my own court, and I've talked to judges in other states, some judges are really, really leery of these special immigrant juvenile cases, and they get all nervous about, hey, I'm not an immigration specialist, and what do I know about immigration law, and am I being scammed here, and do I have to make an immigration decision? And they kind of get all caught up in that. And I think it's really important for judges to focus on the fact that nobody's asking you to make an immigration decision. Practitioners can kind of remind judges of that judges are just being asked to make a decision under their state law. And if they're family court judges, it's the kind of stuff they decide every single day. Is this kid abused? Is this kid neglected? Is this child in need of care? And it's just important to remember that, and then let USCIS sort out the immigration piece of it. So yeah, go ahead.
How could Juanita or Lupe qualify for special immigrant juvenile status?
So this is how it would come to me as a judge in DC Superior Court. More than it would. As I said, I have a neglect case where Lupe and Juanita used to be in foster care, and then I released them to their mother. And now we want to do a custody case. So their mom files for custody. Clara files for custody. And she also, as a motion in her custody case, she will also ask me to make special immigrant juvenile findings. Sometimes those findings are called the state court predicate order. Sometimes I've heard them called special findings about special immigrant juvenile status. It's all the same thing. Like any custody case, the first thing I'm going to think about are the normal things I think about in custody cases. Has the defendant been served? And we'll talk a little bit more about service. And what is my hearing going to look like? My hearing is going to look like any other custody case that I've done lots of times. I'm going to get some testimony, and I'm going to find out a little bit about the story of this case. In Clara's case, she could file a motion for custody of a petition for custody of Juanita and Lupe, but I would want her to file separate motions for each child for special immigrant juvenile status, because the facts are a little bit different for each kid. And I'm going to just kind of run down for you how I would make findings for each child. I would listen to the testimony. I would listen to Clara testify about essentially the story of the case and how the children came to stay with her and how they came to the US and stuff like that. And I would probably also hear from Juanita. She is 14 at this point, and I would want to hear from her. I'm not going to hear from Lupe. She's only 2. But after I listened to the questions that Clara answers, listen to her answers, I would make a bunch of findings. And the way I make my findings in special immigrant juvenile cases is I have like an outline that I go through, and I listen to the testimony and make sure that all the key elements of the special immigrant juvenile status, that the lawyer hits all those points. So the first thing I'm going to do is this child under 21? Now, obviously, Juanita is under 21. Why 21? A custody jurisdiction for us in the district ends at 18. So I have to do this for Juanita before she turns 18. She's only 14, so we don't have a problem. But in order, she could, if she were 17 and 364 days, I could still do it, because the federal SIJ statute talks about a kid being under 21. So then I would also have gotten testimony about Juanita being unmarried. That's usually a question during testimony that gets a little bit of a chuckle or a confused look from the kid, like, of course I'm not married. But I do need to make a finding that she's under 21 and unmarried. And so, I ask that, or someone asks that question. The next thing that I have to do is make sure that I really have jurisdiction. Now, since this is a custody case, I look at the DC laws on custody jurisdiction. And, we have our statute that's based on the UCCJEA, just like I'm sure all the jurisdictions have. And I would make a determination in this case that Juanita her home state is the District of Columbia. She's lived here for more than 6 months, and it meets home state jurisdiction. Sometimes you have one of those weird situations where you don't have a home state, you have to assert emergency jurisdiction, but really this is something that judges do all the time in custody cases. You make that decision, and then I have to make a finding that that she's either dependent on the court. In other words, well, she was dependent, she was in foster care, but now I'm going to place her in the custody of her mother. And when I make my findings, the first thing I would have done is I'm granting mom's motion for custody. And now I'm going to make my SIJ findings. And I'll say 5 minutes ago, I placed her in the custody of Clara, who is a person appointed by the court. So that's all pretty easy. The harder findings are, the next one I have to make is that reunification with one or both of her parents is not viable. And you hear lawyers talk about the viability requirement. Why is it not viable? It has to be not viable because of either abuse, neglect, or abandonment. If you remember from the very, very beginning of our hypo, Juanita was abandoned by her biological father. That's it, we have abandonment. So I would have heard testimony from Clara that the dad abandoned Juanita from birth. And then I probably would have heard some testimony from Juanita that she doesn't have a relationship with her father. He's not providing any support for her, either emotional or financial. And based on that testimony, I would make a finding that he had abandoned her when she was an infant, has failed to provide her with financial or material or emotional support. And I would make a finding that under DC law, even though it happened in El Salvador, under DC law, what happened to her with regard to her father's abandonment constitutes abandonment under our DC statute. Again, looking to local law. Then I have to make a finding that I make a finding that because her father abandoned her, reunification with her father is not viable. In other words, using that word again. And just remember, it doesn't matter that Clara is taking good care of Juanita. We're looking to the actions of one parent. And then finally, I make a finding that it's not in Juanita's best interest to be returned to her home country. Why? Well, the only two people have a right to custody of Juanita, her mom and her dad. And her mom is here in the US, not in the home country. And her dad is in the home country, but he abandoned her. So it's not in her best interest to go back to her dad. Sometimes you get—
Judge Julie, do you always take testimony on this, or do you ever just, sign the SIJS forms without testimony?
So, I always take testimony, but I know that there are other judges that don't. And I was actually asked yesterday in a case, was I okay relying on affidavits, or did I want some testimony? And I was like, no, I'll take some testimony. I prefer testimony. I mean, I think it's just better. If there were a reason that I couldn't take testimony, I might be able to be persuaded.
Because I asked the parties if they have an objection to my reviewing the affidavits, and if they don't, I don't take testimony. but perhaps it's a better practice to take testimony.
I think it's,
Like it.
I think anything that's going to make your order stronger and kind of more solid. So, if you've got, if it's abuse and you've got a young child, you may not take testimony in the same way as you would from an older child. But the point is that you need to get the evidence in such a way that you are making, under your state laws, sufficient findings. I mean, in terms of, that the ones that you need to reach. And that's the main point. I think there's flexibility because the practice is different everywhere, but it's never a bad idea to take testimony. That could never be they're both possible, but I think it may be preferable if you can to take some testimony on the record.
I think, you had some sort of weird circumstance where I couldn't take testimony, I'd be okay with the affidavits, but I prefer the testimony. So I would do the same thing for Lupe, but I would do a separate order for her because I just think it's better to have standalone orders for each kid. And again, I would find, now I didn't take testimony from Lupe, I'm going to base it all on what her mom said, but she's under 21, she's unmarried, I have jurisdiction as the home state. I placed her in the custody of her mom. And for her, reunification with her father is not viable due to abuse. It's easy, that's an easy finding because, as we discussed, he was convicted. And based on that conclusion, I would say that she's an abused child under DC law, and that it's not in her best interest to reunify with him because he abused her. And just again, focusing on one parent is all you need to do. And I would also make findings that it's not in her best interest to return to the country of origin because there's no one to care for her. Only her mother and father have a legal right to custody. Sometimes lawyers get into a lot of questions about could she live with her grandmother? Could she live with her cousin? And I don't mind hearing from that. I think it's kind of makes a nice, stronger case if there truly is no one else. But remember that the grandmother, the cousin, all those people don't actually have a custodial right. So I would make a finding that it's not in her best interest to return to the home country. And again, reiterate that remaining in Lupe's custody is in the child's best interest. And, I make best interest determinations every day. This isn't that different. And I believe I mentioned the separate orders. I like to do separate orders for each child, but that's sort of how I would do an SIJS case in the context of a custody and neglect dependency case.
And what other kinds of proceedings have either of you, could the findings potentially for Juanita or Lupe be made? I mean, what are the kinds of ways where they might encounter the court where a judge could do this?
I mean, pretty much anything you can think of in family court. So in DC, I've made those findings in neglect cases. Yesterday, for the first time, in all the time I've been doing this, I did it in a delinquency case. I do them in custody cases twice a week, every week. You could definitely have these findings made in a domestic violence case, a child support case, an adoption case. I'm trying to think, probably a guardianship, some forms of probate relief, I think, but it's a pretty much any time you're dealing with kids, I think you could do it.
Yeah.
Exactly.
Our probate judges have seen a lot of SIJS requests. I have seen a lot of requests in delinquency court, and I'll have a child who has come to the United States, has been forced to sell drugs, has been trafficked, and it is labor trafficking. Or has been forced to sell themselves, and are CSEC children who've also committed or allegedly committed some other kind of crime and end up in delinquency. And it's quite common to issue special immigrant juvenile status findings in delinquency court.
And if Danielle, if you can go to slide, I think it's where to go, 40, I think it is. One of the things, because Judge Breslow mentioned this when she was talking, and I want to make sure that we don't miss it, is that we just came out with a brand new tool. In fact, Daniela finished working on it this morning or yesterday, where you can look up the service of process rules. So as I understand it, and Judge Breslow and Judge Briel, please check me on this, but as I understand it, the people that need to be served are determined by whoever needs to be served under state law in that type of proceeding. So as Judge Breslow said, if in custody, if it's only mom and dad, then it's not grandma, uncle, and cousin. And so, but when you're serving whoever you need to serve, there are a lot of times we find in these cases, judges get tripped up on, alternative forms of service. And the main issue, one of the mantras I think you're going to hear throughout this webinar is just follow your own state law, your own rules, the way it's normally done. And we lay this out and compare jurisdictions. And also you can look up your state on these charts and see how your dependency court differs from your protection order court, differs from your custody court, et cetera. And so we've got all the state laws for you, which I hopefully will be a tool that'll be used for everybody. And we're showing it to you for the first time today.
So that's really important because, Juanita's father abandoned her in El Salvador. And I've had cases where a father might be in Honduras or Nicaragua or El Salvador, and they live 3 blocks from the church, around the corner from the post office, and that's their address. And the parties don't know how to serve the parent living around the corner from the post office. So Judge Julie, you want to talk a little bit more about that? I mean, it's kind of disturbing to the attorneys. How do we affect service?
I think it really depends on it. Is there anybody first of all, you follow your local rules. That's the first thing. But the second thing is there, on a practical level, is there anybody in this case who actually knows where this guy lives? If you do know that he lives in the 3rd house next to the post office before you get to the church and it's yellow, like if you actually have that information, you may actually be able to serve him. And so you may have to get, a process server or an investigator or someone to do that. Those cases aren't that hard to me because that's a findable person. I think cases with people who aren't, like Juanita's father, he really may not be findable. Clara hasn't heard from him in 14 years. She hasn't been in the country in a long time. I would want her to make efforts to figure out where he is and ask her family, do you know where he is? But if she simply has no idea where he is, I would want her lawyer to file under our local laws a motion for alternative service and to suggest to me a way to serve him. Could be publication, although we don't do that very often. Could be posting. We actually post on our court's website now, which I think is a pretty good way to do it. But it just depends on, is this person actually findable or is he not?
And in most cases, I think that we don't know that he is 2 blocks down from the post office. We'll have the mother say, I have no idea. I haven't seen him in the 14 years of Juanita's life. And so then our local rules in California would allow publication in a newspaper.
And then in that newspaper should be the same newspaper that the court rules tell you to publish. Like, for example, some states will even say publish in this paper. and so that's what it is. And you don't have to go find another paper in the other country. You follow your court rules. So I just want to move forward for a second to slide, I think it's 46. And just want to touch on a couple of things before we move on to U visas. And Judge Breslow definitely talked about this. You want to really look at the best interest of the child and where the placement is. And that's the crux of the best interest determination. Beyond that, if there are gangs or if there are other dangers to the child in the home country, that's kind of extra. Because without getting to, they should be a part of your best interest in the way you think about it. And we have some slides, the next 2 slides have materials for you on take homes of things you can think about as you do that. Next 2 slides, if you could show them quickly. Yeah, so the kinds of things you want to think of in best interest are here for you next. And then so you don't have to, and then on the viability question, which is slide 51, I believe. The point I want to make here before we move on is that as to this reunification not viable, termination of parental rights is not required. This is nothing like, a child welfare case where you're going to terminate somebody's rights and then adopt the child. And there can be contact. It doesn't mean there's no contact. It just means you, judge, have just ruled that, you've done your service. You have the parties on before you that you're going to have. You're going to make a ruling that is going to be permanent in the life of this child, absent a change in circumstances in the future, and that's appealable. And that's enough to make a determination about whether you envision in the foreseeable future, right, from the fact you have right now, reunifying Juanita with her abandoned parent, for example. And now I think,
did you want us to talk about some best practices?
Sure, yes.
Judge,
next slide, please.
So I think I have some standard form SIJS orders that I use because I've been doing this long enough that I found that there's language that I like and language that I don't like. I think one of the most important things is that as the judge, you're really, really clear in your findings. Don't be roundabout, be very, very clear. I find that it is in the child's best interest to be here. I find that reunification is not viable because, sentence. And just be very, very specific in your findings. You don't want to be sort of pro forma, like you're just checking stuff off, though, okay? You want to add fact-specific stuff, like stuff that's specific to this child and this family. And that's why I'm kind of cool on using affidavits. I feel like it's more vivid when I hear testimony and allows me to make more robust findings. I will also say, I can't tell you how often I get pleadings and with affidavits, and they tell one story, and then the story that gets told in testimony is like totally different. So I don't know, I just go with the testimony. Lots of detail, you can't have too much detail. And remember that the child's motive in coming to this country is not relevant. So sometimes lawyers get tripped up in like, he came here for a better life, and he came here for an education, or he came here to flee gangs and threats and crimes. Like, it's just not that, it's not that important. So those are my best practices. And listen to the child.
I think don't consider motive is extremely important. And there's a case in Professor Orloff's materials. It's the Leslie H. case out of San Diego, California. And the judge did get tripped up in thinking, well, that this applicant really wants to be here in the United States. It's up to the USCIS to make a determination whether there's an ill motive. It's not up to us. And that judge also said in the Leslie H. case, why should I let her stay here? It's not in her best interest to be here in the US. She's committing all these crimes and robbing a grocery store and stealing liquor. Well, that's not the standard. The standard is whether it's in her best interest to return to her country of origin. And her country of origin happened to be Mexico in the Leslie H. case, where she was tied to a chair and starved and beaten. So not considering motive is very important and an important best practice. I think that we're going to move on to U visas. And
so my question to you, Judge Briel, is why could Clara, Juanita, or Lupe qualify for a U visa? How does that work?
Well, we have to first decide whether Clara, Juanita, or Lupe, or all three, are victims of certain qualifying crimes. And there's a whole list of qualifying crimes, if you go to the next slide. And it's not just these crimes, but any attempt to commit these crimes to victimize Clara, Juanita, and Lupe, or any related crime. So we have to ask, are these individuals that we have in our hypo victims of these qualifying crimes? And first, let's look at Clara. Certainly, she is a victim of domestic violence. She's a victim of sexual assault. She's a victim of attempted murder. She's a victim of felony assault. And she's a victim of trafficking, of labor trafficking. You also have false imprisonment there. When Eduardo was strangling her, she was probably a victim of false imprisonment. She's a victim of all these qualifying crimes. And if you look at Juanita, Under our hypo, Juanita was a victim of labor trafficking. She was beaten by Eduardo, so she's a victim of child abuse, and she's a victim of felony assault. As for Lupe, the infant, the 2-year-old, she was beaten by a belt, so she's a victim of felony assault and child abuse. So the next question, once you see that they are victims of these qualifying crimes, is whether they are helpful or have been helpful or are likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of a case. Well, they have given information to the police officer who arrived on the scene. And, you know, I am assuming that Juanita probably gave information to the social worker when the dependency case was started. So certainly helpfulness can be calling 911. It can be showing your injuries, talking to a police officer. For Lupe, you know, if she is showing where it hurts her, that's being helpful, but she's under 16. So actually, her parent, Clara, can provide the helpfulness element for her in our particular hypothetical. And helpfulness is any credible evidence of helpfulness. It's really kind of a probable cause standard. You know, the case doesn't even need to be filed by the prosecutor, and they would still qualify as victims of these qualifying crimes and as having been helpful, even if there's a later decision not to prosecute the case. So they testify in front of Judge Julie and her dependency court about wanting a civil protective order, or perhaps they're trying to get a criminal protective order. That would be helpful. It doesn't have to be helpfulness in a criminal court. It doesn't have to result in a conviction. It can be helpfulness in any one of these range of court cases you see on this slide. Perhaps Eduardo's trying to evict Clara and Juanita and Lupe from their apartment, and it ends up in housing court as a landlord-tenant case. And Clara says, well, he's just trying to evict us because we talked to the police when he beat us and tried to rape me. That's being helpful. It can be in any one of these court arenas. And remember, it's any credible evidence standard. So let's see, next slide.
So my question, and this is for the audience to weigh in on the chat, why would victims seek a U visa certification from the state court? So type in your answers. Why would these victims seek a U visa certification?
Choices are, you know, A would be the only justice system contact they had was the protection order, divorce, civil employment case, the landlord-tenant case, child welfare. B is they called the police for help, but there was no language access. C is that the judge observed the victim's participation and attendance in a criminal court proceeding, or a civil court proceeding for that matter. And D is all of the above.
Yeah, the answer is D. It's all of the above. These are all good reasons for seeking the U visa certification.
So, and often you will have a non-citizen who might be afraid to call the police, but they really want a protective order. So they go to a different court, not the criminal court. Or you might have a child who's run away and who, you know, is now selling drugs and ends up in delinquency court, but talks about having been beaten by a parent. And so that they would qualify in delinquency court for a U visa.
So, Judge Susan, can any judge sign a U visa certification?
Well, just about any judge, federal judges, state judges, magistrates, aldermen, commissioners can sign. All of the judicial officers you see on this slide can sign. Absolutely.
So, but Judge Briel, does it have to be the judge who heard the case, or could it be a different judge?
Oh, no, it can be a different judge. It does not have to be the judge who hears the case. And maybe the case is ongoing, and perhaps the judge doesn't want to insert himself or herself into the actual case by signing a U visa certification request and looking like the judge is giving a benefit in their courtroom to the party. So often a best practice is to designate a different judge in the courthouse to handle U visa certification requests, which is what we do in my county. So it doesn't have to be the judge that actually heard the case, as long as you have evidence of helpfulness and the party is a victim of a qualifying crime. So no, it doesn't have to be that judge.
Right, and it would be, so what happened is the helpfulness could be all kinds of things, as you said, coming to court and things like that. And that if a judge, just so people know from a judicial ethics perspective, if you have an open case, let's say you're a smaller jurisdiction and there isn't another judge to go to, and the victim really needs protection now and can't wait until the end of the case. First of all, 95% of the time, judges are signing certifications once the courts have ruled in some way or another, and the case is, well, the court's finished with the ruling. But in some cases, you really need to do it when there's an open case, and then it's notice and motion practice so that the other side would be informed about it. Other than that, the Vowel confidentiality rules are apply, and once a court has ruled, you're going to attach your findings to the certification and say, this is what we found. And so you're certifying, you're not kind of adding evidence, so to speak. And you don't have those ethical issues because you've already ruled on the case.
So that's correct. And that's also really interesting because you may be signing a U visa certification request, which triggers confidentiality. And then all of a sudden, one party wants to know, well, was there a U visa? And the question is, well, maybe not. It's confidential information. And then you do a whole hearing about that.
And it's not discoverable. We have whole webinars on that. We can get you lots of information on Vowel confidentiality. But generally, the only thing that would be discovered would be a cert by a judge, by a police officer, by a prosecutor. That would be a normal part of the prosecution's case. It's not anything outside of it's not the immigration file that's discoverable under any circumstances.
So as far as who else can certify, social workers, child protective service workers can certify. I don't know, Julie, if you're seeing that in your state. I'm not seeing that. They are aware of it, our social workers, our child protective workers, but for some reason, they're not signing these U visa certification requests.
I will say that I'm not aware of any participation by our social workers. When I worked at the U.S. Attorney's Office many, many years ago, I did see prosecutors signing these.
I think it's also important to let everyone know that there's no statute of limitations. So if Clara were to come 10 years from now to Judge Julie and ask her to sign a U visa certification request after all is said and done, or 15 years from now, she could still sign that request.
Go ahead. One of the reasons, I mean, these are the other agencies who can certify. And so one of the questions becomes, if you're in a jurisdiction where your prosecutor is not certifying or your child welfare system isn't certified, is there a role judges could play in maybe trying, because one of the reasons people end up coming to the courts is because the other agencies that can certify in the community often are not doing so. It's only one of the reasons somebody in a protection order proceeding, for example, is only availing themselves maybe of the courts. So the court may be the first and only, but in a case where there's been police or prosecutors involved or child welfare, there are other agencies.
Go ahead.
You go.
No, the other thing it's important to know is that USCIS has to make other findings, but that's up to them to make. It's sort of like what Judge Julie was saying before, let them make the decisions that they're going to make and let them decide whether the candidate is worthy of lawful permanent residency or, naturalization, that's all up to them. We have to make very few findings for a U visa certification. We do not need to decide if the applicant suffered substantial physical or mental abuse. That's a requirement the USCIS has to decide, but it's not something that us judges have to decide.
That's a good point, Judge Briel. One of the things that's important, you were talking about early on, all the different crimes that you could detect that Clara suffered. One of the reasons you want to be very detailed about checking all on the certification form, checking all the boxes that apply. So not only attempted murder, but the sexual assault and the domestic violence and the human trafficking, is because when a victim files her case, she has to prove substantial harm, and her proof of substantial harm has to match up with one of the criminal activities that you checked off. So if you only checked off labor trafficking, she could prove harm from labor trafficking, but it might be a lot easier to prove harm from domestic violence or sexual assault. You see what I'm saying? So
yeah,
it's important.
absolutely.
So it's important. That's one of the reasons certifiers are encouraged to check all boxes that apply.
I think that's absolutely a best practice, to list as many crimes that qualify in the U visa certification request and your local state statutes.
Can you tell us, can you go to slide 65? And maybe you can tell us, there's some examples just so you have them for your records of what you'll see in criminal or civil cases that might be enough for helpfulness and certification. But Judge Briel, what are you telling USCIS on, what does the certification form ask you to say?
Well, it asks, the actual form is the I-918 supplement B, and the language on the form asks based on my investigation. Well, we're judges, so we don't investigate. So I would just cross that out. And it would be, based on the restraining order I issued, or based on the testimony I heard, or based on the conviction or the sentencing, or based on the testimony of the crime. So that's what you're asked to do. You're asked to say, based on this finding of fact that I've made, the applicant is a victim of a certain qualifying crime. I would put, for instance, in California 273.5 of the Penal Code, which is domestic violence, 664-187, which is attempted murder. I would list all of the crimes, and I would be very careful to list every single one, because as you said, Professor, when it comes to going in front of USCIS, maybe one crime that Claire is a victim of rings truer to the federal government than another crime, depending on her testimony. So I would list every single crime and I would attest to her helpfulness in the, and all I have to do is detect that she's been helpful. It's detection. It's not investigation for me. Maybe there's no prosecution. We have many cases where the district attorney decides not to prosecute. So all she has to do is be helpful in the detection of this activity, or the investigation, prosecution, conviction, or is likely to be helpful in the future. And we are attesting to that in the application form.
But one thing that's important with judges, and next slide, please, while we're doing that, is that judges are very seldom certifying based on future helpfulness. By the time they've come to you, they've been helpful because they've shown up in court. They've come to court. They've gone to police. So they've done something. So very seldom are judges actually in a position. You almost always certifying what's actually already happened.
I think that's true. I've never certified on future helpful.
No, and you're not asked to. Judges are never asked to. And the case could be ongoing. It could be closed. It could be settled. It could have occurred a long time ago. There may or may not be a criminal prosecution. Next slide. And this is just a checklist for you, that there's not any particular thing that's required in terms of certification. The offender could have been arrested or not. There could be charges or not. It could be a civil case where they're talking about domestic violence or child abuse. That's sufficient. There's lots of different ways. So the next slide, what are there some best practices, Judge Briel, that you'd like to share on visa certification?
Sure. I think we've talked about listing every single crime that Clara or Lupe or Juanita are victims of, not just one crime. And I think that also a best practice is to develop a model protocol in your state or your jurisdiction, because it's helpful to know for litigants, for applicants, where they go. We work in bureaucracies, and it's confusing for a citizen, let alone a non-citizen, about where to go to ask for a restraining order, where to go to get help, where to go as a self-represented litigant, and where to go to get someone to sign a visa certification request. So there are model protocols. We have one in San Francisco that I developed with the enormous help of Professor Orloff. So I think if you look at San Francisco's protocol, and there are other state protocols, it's helpful. In Los Angeles County, there is one judge that handles all visa certification requests, both for criminal and civil court. And it gives guidance to the parties themselves, as well as the attorneys, about how to meander through and wade through the morass of the bureaucracy, and how to get a visa certification signed, and also how to handle the visa certification if there's an ongoing pending case.
Right, and the next slide shows you kind of the ways in which the form can be amended, similar to what Judge Briel was talking about before. We are going to move on. Anything else you want to say about the form, Judge Briel?
No, I think we've covered it pretty much.
So next thing we're going to talk about is T visas. Next slide, please. So Judge Julie, what forms of human trafficking did Juanita experience?
So sex trafficking and labor trafficking.
And can you, Professor Orloff, talk a little bit more in detail about sex trafficking?
Absolutely. Next slide, please. So sex trafficking, this is the legal definition of sex trafficking under federal law and under the immigration law as well. But this comes out of the Trafficking Victims Protection Act, so it's broader than immigration law. But basically, you have to have a process, which is the recruitment, the harboring, obtaining somebody. I mean, I think about it. I worked on a case once where workers came to work in the morning. It was mostly a female crew of people working in a poultry plant, and the employer locked the door from the outside when they got in. And they didn't know when they would ever be able to leave that day. Sometimes it was an 8-hour shift. Sometimes it was a 20-hour shift. It didn't, that's obtaining somebody. That's the way I think of that padlock on the outside door as one way to control somebody's movement is obtaining. But you have to have one of these processes. Then you have to have force, fraud, or coercion involved in the sex trafficking, unless the victim is under the age of 18, and then they're exempted from proving force, fraud, or coercion. And then the outcome has to be some kind of a commercial sex activity. So where money, drugs, food, shelter, clothing are exchanged or part of the process of the trafficking. Labor trafficking is the next slide, is similar in that you have to have a process, a means, and a purpose at the end. Here, the process is, again, recruitment, training, transportation, obtaining somebody. You have to have force, fraud, and things like coercion. It's more or less coercion, but a slightly different definition in the labor context. And most importantly, there's no federal, even child trafficking. So Juanita would have to prove that how she was forced by Eduardo to work, why she was forced, why she felt she was forced to work. Either that or, through threats of harm, which may have been, ongoing child abuse could have been enough, would be enough to show harm as the means to coerce her labor. And then there has to be a purpose, which is involuntary servitude, debt bondage, slavery, or peonage. And involuntary servitude is what you're seeing here. I mean, Clara and Juanita weren't volunteering to work for Eduardo's family business and not getting paid. It was part of the pattern of abuse. And so there's very good definitions and information about that available. Next slide, please.
You know, I handle a calendar also that involves domestic child sex trafficking and a lot of survivors. And Juanita ran away from home, and she is not, assumed she's not willing to cooperate in the investigation or prosecution of her traffickers, her sex traffickers. I would never ask the youth in my court, well, who was your trafficker? And they would never tell me who their trafficker exploiter was. So my question is, would someone like Juanita or the young people in my courtroom have to cooperate and point fingers at their trafficker, Professor Orloff?
And next slide, no. They basically, children have an exemption from the cooperation requirement in both the sex trafficking and the labor trafficking context. So it's a little bit confusing, and that's why we gave you the slide, because labor trafficking kids have to prove force or coercion, but no children have to prove, have to point the finger at the trafficker or have to cooperate to get help under these trafficking laws. Next slide, please.
So is there some new law about being forced to work by an intimate partner? I thought there was new legislation, federal legislation about
yes. Well, it's not legislation. Next slide. Is that it's guidance. So there's a brand new tool that was released last week by the Department of Homeland Security. It's in all the materials that we're giving you. There's a policy manual for adjudicators at the Department of Homeland Security and a resource guide for T-visa, for certifying T-visas that just became available. And what's important to understand, it gives you these definitions of involuntary servitude and how you prove that in the domestic violence context, and how the role that threats, abuse, and intimidation can play. And it really is very clear about how this trafficking can happen in an abusive domestic violence relationship. And this is the details of that information. Next slide, please.
So what is the information that's needed to be provided in a T-visa certification request or declaration request?
Right, and here too, the materials, next slide, provide really good information on this. They're gonna identify the type of trafficking, not the trafficker necessarily, but the type of trafficking. Is it sex? Is it child sex? Is it labor? What kind of victim, how were they victimized? They might want to identify the relationship between the crime detected and, what is or is not, what are you looking at in your court? What might be an under investigation or beginning, what have they reported to investigators, that kind of thing. They'll ask about, this is something where judges can really help. You often have, when I'm thinking about Judge Breslow a minute ago, you were talking about the kind of testimony you get. You have good information sometimes about threats of retaliation. So making findings as a judge about retaliation or revenge or the fear that the child or the adult has of the trafficker is super helpful, because that's a key part of their immigration case, and where a judge's orders or findings can be really helpful in it, and putting it in the certification can be helpful, but also making findings on the record in in the case you're hearing could be helpful. Dates of the trafficking, statutory citations, just like Judge Briel was talking about earlier, about citing California sites on U visas. Think about it this way. You have adjudicators sitting in Nebraska and Vermont, and they're seeing all the cases from everywhere in the country. And they're not going to be able to correctly look up your code section of the law to know what was the code section in Nebraska or Missouri or DC or San Francisco. So providing those citations is super helpful to them. And then information about the victim's involvement with the case or cases. And that, again, could be involvement with the court, involvement with child welfare, involvement, any kind of involvement at all. even though it's not required of a child, it is required of adult trafficking victims. And it can be with various different parts of the justice systems, to think about it broadly. And most importantly, the name and the relationship of any family members involved in trafficking. Next slide, please. What's important to understand is, especially in child trafficking, in 2 out of 5 child trafficking cases reported nationally, there's sex child trafficking involved, and in 62.7% of those cases, a family member is involved in the trafficking. And so you as family court judges see families all the time, and being able to detect the trafficking is really important. We have data here for you, more data on family-related trafficking. Next slide, and and who is being trafficked nationally from the trafficking hotline that you can review at your leisure. Next slide, please.
So I'm not seeing a lot of, I haven't seen anyone come into my court and request a T visa certification. And I don't know if it's because of lack of education of the attorneys. I'm not sure why. What's your experience, Judge Julie?
Nope, I'm not seeing it either.
Okay, so that is not unusual. We do trainings all over the country. And I think what's happening is, because the certification is mandatory in U visa cases, and a preferred, or not a preferred, it can't even, and a piece of evidence that's very useful in T visa cases, sometimes lawyers will take a shortcut, right? They won't go back to the judge and ask for trafficking certifications in T visa cases, and they really should. So this is an area where, as judges, if you detect a trafficking victim in your court, is there something you could ask of the child's attorney or their attorney to do? Or what might you be able to do to kind of, if you're the one that sees this first, to trigger maybe them asking you for a certification?
Sure. I mean, you could certainly hand out brochures on trafficking and T visas, or brochures prepared by USCIS. I have been known from time to time to appoint immigration attorneys in my court.
Yeah, I've done the same thing with appointing immigration attorneys, or recommending to an attorney who is not an immigration attorney, your client may need some assistance. I think you should connect with Kids in Need of Defense, or our legal aid, organization, or other organizations right for the city, legal services places that we have in our city that do immigration work.
And I've worked with judges who've suggested that they, have you heard of the T visa council? And would you come back and brief me, on whether or not, would you take a look at it, report back to me on what do you think, whether this might be a possibility for this child or something. I mean, you could potentially do
or
it
maybe
that way
even
too.
Putting it out there. Take a look at the U visa or the T visa statute, U visa statute. If you think your client's eligible, come back to me. I might be willing to sign that for you.
Right. I have said off the record, I'm not an immigration lawyer. I'm just a judge, but maybe you'd like to look into a T visa in this case.
Yeah.
I love it.
Yeah. So we're going to skip now, because we're coming to the end of our time, to slide 85. And I just want to make, we have resource materials on all of these that we'll send you. And I just want to do a closing remark on the Vowel self-petition, because we started with that and you saw it was one of the forms of relief. And this is an area where, as I said earlier, making findings that, when you, just as Judge Breslov was talking about, or Judge Briel, with all of these, any of these cases, giving out brochures and information at the court about these forms of immigration relief, along with your publicly available information. There's great materials that DHS developed. So it's not an advocacy organization doing it. It's the Department of Homeland Security's materials that you can hand out. We have those links for you in a section on the materials that we're providing with the webinar. And making really good findings about domestic violence, abuse, family relationships will be super helpful to U visa victims, T visa victims, SIJS children, and VAWA self-petitioners as well. So there are a lot of good things that judges can do. Next slide. I think it's 88 or 98. 98. Next one. 2 more. Next. There we go. And, or I guess, how does all of this help judges? Is there some reason, are there ways that, you've seen, kids you've worked with or adults you've worked with where you've seen this immigration process really make a difference in their lives?
Absolutely. I've seen young people who were hidden by the parent, the custodial parent, and not go to school because they were afraid of being removed from the country. I've also seen kind of egregious situations of children being put out to work instead of go to school. I've seen parents really afraid of what's going to happen since or not talk about crimes even. I had a woman in my court say, he can beat me because I'm not a citizen. And so this really helps. This information, when I know this information and I can talk about it to the parties that come before me, it helps them become better parents if they access services, they access legal options and remedies under the Violence Against Women Act. Judge Julie, your thoughts?
I mean, the same thing. I think the fear of deportation is just profound, and anything we can do to help people not be so worried that that's going to happen if they have a legitimate way to get legal status, we want that to happen, particularly when you've got and I've had this happen before, when you've got US citizen kids and undocumented parents, where we want the parent to do all kinds of services in a neglect case, for example, and the parent is just terrified that whatever they do, they're going to come to the attention of authorities and get deported. I can get them better engaged in services to safely reunify with their kid if they're not afraid to go to the services.
Exactly.
And removing that fear of deportation is a really huge burden you can help lift.
So it goes back to the study that you have published.
Next slide. Yeah, exactly. It does. It goes back to this next one. It goes back to the next slide, please. There we go. So it goes back to the study, and it shows that it's true that as people start getting immigration relief, they get more engaged. And we have training and tools and materials that we can give you that are on this slide and that we'll send you by email after the presentation. Please, if you're a judge and you're not a member of our National Judicial Network, please consider joining us. We'd love to have you. And please do fill out the evaluation form for this. Next slide, I think, is the last one on the evaluation for this session. We are supported by SJI and OVW. We'd like to be able to tell them how it went from your perspective. And I really want to thank you for joining us today. Thank my co-presenters, Judge Briel and Judge Breslow. This was wonderful. You did it. It was really great. I think everybody enjoyed it. And I hope this helps all of you in the encounters you have with immigrant children and immigrant survivors in the future. And we are here for technical assistance and training. We can link you up to judge direct technical assistance. So if you want to talk to another judge about an issue, we can make that happen. So please do consider joining the network. It is a place where judges can learn from judges in this way, as we've done here today. And hope you'll join us in the future. Thank you so much.
Thank you to our participants. Thank you.
Thank you, everybody.